Harry here to talk about the big oral argument in the tariffs case in the Supreme Court this morning. First, let me try to get at its magnitude. You know, the Supreme Court has had a series of shadow docket cases in which it largely has ruled for the administration. They've left many people, me included, disconcerted. But because of the pace of the law, they haven't had a actual on the merits full treatment of important issues of executive power. This is basically the first, or at least it's gone to the head of the line with oral arguments scheduled and regular briefs and amicus briefs and questioning from the justices, etc. The case involves Trump's effort to use, surprise, surprise, emergency powers as a way basically to impose tariffs anywhere he chooses for whatever amount he chooses and to change them basically to be the central economic control for the world as far as the United States go. And without even getting into the fine grains of the argument, the immediate issue is that sure sounds like taxing. And taxing is something that is quintessentially Congress's job. Could, however, Trump, now in the Supreme Court, which has been solicitous of his declarations of emergency power, say, well, you know, it feels like a tax, but Trump calls it something different, and we have to defer to that. And the answer after today's oral argument really seems to be no, they're not going to go for it, which would be a very sort of sanguine development. It would suggest, you know, in broad strokes that the court is quite aware of its overall place in the separation of powers, that it is solicitous of the president, maybe doesn't even want to get into disputes unless it matters, but that this one matters. And nearly every member of the court, including the Trump justices, Gorsuch and Barrett, Kavanaugh less, seemed very skeptical and gave a very hard time to the administration lawyer, the Solicitor General John Sauer, about this assertion of power from Trump. And remember, this is something Trump has said. I mean, he's playing a game of chicken kind of with the court and the country. He's done all these things. They've let him do it temporarily. If they go the other way, query, you know, we should have such problems, but why have they let it go so long without stopping it with some kind of temporary injunction? But anyway, if it should go the way that it looks, Trump has said it will be complete bedlam. The economy will be absolute chaos after all he's done. And, you know, the short answer to that is maybe you should have thought of that before doing it without having the legal green light to do it. But coming into this case, and I'm among them, most commentators saw it as less hard than really up in the air. There are cases that seem really of a piece with what the court has already given to the executive. Others that just seem so basic, like the Illinois case, we're still falling very closely, involving his assertion of emergency authority to federalize National Guard members, and now this one. And so-called center justices seemed to really be together in their skepticism. You had Justice Kavanaugh, who seemed to be fairly pro-Trump, saying, you know, you really don't want to limit his emergency powers, and there are certain powers we know that he has that are even more severe than this. But otherwise, there were, you know, the thrust of the questions were, have we ever done this? Like Justice Barrett, very important vote. Why every single, is there really an emergency to the defense and industrial base for every country? I mean, Spain, France. And what does that mean? That means a second guessing on the facts, which is the most important point in this whole flotilla of cases in which Trump has invoked emergency powers. He's done it on the basis of confabulated, well, as I always have, lies about what's going on the ground. Okay, so there was some effort by Kavanaugh's questions, by Sauer to invoke certain action by Nixon, but many years ago. But the justices said, this just hasn't happened for 50 years, and they're a little bit caught up in their own holdings of late, because they have sort of revived, not completely, but somewhat, and the argument that Congress can't delegate too much power to the executive, the so-called delegation doctrine. And if it's really true, obviously the taxation power originates in the Congress. So he's basically saying that with this statute governing emergency powers, Congress has said to him, man, when you think it's an emergency, boss, just take all our powers away and do what you want. And for the court, in addition to the kind of Alice in Wonderland aspect of it, that, this is a tax, there's the additional problem of it feels like over-delegation by Congress, which they've been very sort of tough on trying to police. In a similar way, Gorsuch talked about separation of powers, which was a sort of shorthand for saying this is, what the power to tax, and that just goes to Congress. And Gorsuch actually raised a point that many, progressives would say about the court's jurisprudence. He warned, he said, of a, quote, one-way ratchet toward the gradual but continual accretion of power in the executive branch and away from the people's elected representatives. Yeah, hallelujah, no kidding. And it's so much based on what this court has done. It's done it also in a doctrine that reared its ugly head, and they'll have to try to figure out in this case, namely the major questions doctrine, in which they have said before, if it's a really big deal, and what could be a bigger deal than this, then under their major questions doctrine, which they kind of made up, and this is another discussion, but I think is flawed and is going to give them trouble going forward quite a bit. But this would be the kind of major question that Congress would have been express about, under this emergency statute, if you want to use tariffs. And remember what we're talking about. Basically every country, Spain, France, but also China, Canada, Mexico, and if he feels like increasing it because he says drugs, or he feels like decreasing it. I mean, it's the classic kind of Trumpian move of imposing very strong across the board regulations, and then individual countries have to come to him on bended knee so he can bestow on them an individualized exception. Such a total, typical, prototypical assertion by Trump of the power to make a deal. The exact opposite of what tariffs and economic policy, which are premised on predictability, are supposed to do. So the statute here, which is at the center of the argument, of course, doesn't use the word tariffs, doesn't use the word taxes, doesn't use the word duties. The word it uses is regulate. When there's a very extraordinary threat, a national emergency to the foreign policy or economy of the United States, then you can regulate the importation of foreign property. That's the whole hook that the administration uses to try to justify the power to levy tariffs. But besides these specific doctrinal problems, just take a step back and appreciate how breathtaking that assertion is. They say you can regulate the importation of foreign property when there's an emergency, and he's using it to impose a kind of planned economy or international economy where he alone gets to say, let's leave taxes out of it, even for this sentence. What monies we demand from others in order for them to give to have their goods as part of the American economy, and the like. It just is such a intrusive level of, you might call it, regulation. The tariffs that the administration has proposed under it, by the way, cover roughly a third of U.S. imports. So it's humongous. The Court of Appeals for the Federal Circuit, those are regular Article 3 judges now, but they are specialized for knowing these kinds of international methods. They struck it down. It is not, by the way, a liberal court or conservative. It's a specialized court, but it's one that the Supreme Court respects. So they said the emergency statute that Trump relies on just doesn't give him this power. The way they put it is, if Congress were going to delegate this kind of breadth of power, it would need to do so explicitly. So we're really talking about the prospect that is revived since the oral argument. You can actually see the Wall Street Journal has an article with certain predictors, even a market. And it was, really in equipoise. And after the oral argument, the prospects by these bettors, but sophisticated bettors of the administration winning, went like, whoa, really plummeted. It was in some ways, in that sense, a surprising oral argument, and it seemed to indicate that 6 or 7, anyway, of the justices, A, understand the stakes, and B, understand the grand implications for separation of powers and the wresting from Congress of something that is just bread and butter for them. A trend, of course, that the Supreme Court has done much to facilitate, but that it seems ready to stop, at least here. And that would be huge. Just doing it, besides the holding itself, which would be very significant in practical terms, that the Supreme Court would, after giving ground, draw a strict line. And in this case, the first one to really consider these outsized emergency powers and whether they, in fact, just usurp Congress's Article 1 authority. That would be a really big, really encouraging, really historic kind of ruling. So we'll see if they go that way, as the oral arguments seem to portend. They're going to be having this one in submission for a while different opinions circulate. It could even go all the way to the end of the term in June, but no later than that. And this is very possibly a case for the ages. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.